Morning. Mr. Sandler.
Thank you, Chief Judge, and may it please the Court.
You'll have to speak up a little louder.
Yeah.
Thank you.
May it please the Court, this case presents the question of whether a law enacted by the General Assembly that changes an element in a statutory formula such that the governor is required to include additional amounts of funding for a state program in future budget bills, all for the purpose of conferring a financial benefit on a group of Marylanders, whether such a law can be put to a popular up or down vote before the General Assembly even has a chance to consider those budget bills, the statutorily mandated proposed appropriations in them, or whether instead such a law is exempt from referendum under Article 16, Section 2 of the state constitution, exempting laws making appropriations for the maintenance of state government. We submit that under the precedents of this Court, as a matter of logic, such a law should and must be exempt from referendum, and that the Maryland DREAM Act is a law of this kind because the bill, according to the Department of Legislative Services, will require the governor to include additional amounts in future budget bills for support of community colleges, as well as in reducing tuition revenue to the University of Maryland system, all for the purpose not of changing a policy, but of conferring a financial benefit on a defined group of Marylanders, and that is young people who grew up, attended Maryland high schools, worked hard, graduated, whose parents have paid Maryland taxes, but who for various reasons could not establish Maryland residency. And the Maryland DREAM Act would allow those young people to pay in-state tuition at community colleges, and after meeting other conditions and attending community colleges, pay in-state tuition in the University of Maryland system institutions. I want to make just three brief points here. Come back. First of all, that a bill directing the governor to include future amounts in future budget bills should be subject to the appropriations exception, even though that bill itself does not, like the DREAM Act, make an appropriation or raise taxes. Secondly, the test of this Court in terms of the primary object is not the subjective intent of the General Assembly in passing the bill, whether that was to make an appropriation, but whether the spending, the fiscal dimension, is a primary effect or object of the bill rather than an incidental one. We submit that test is met here. And finally, if the appropriation exception is extended to law of this type, it would not open up a vast array of bills to the exceptions in a way that would gut the referendum right, because there are actually very few statutory formulas of this type in the law. The word what
are the hallmarks of this bill? What are the hallmarks of this bill specifically that you would point to say this is an appropriation? I mean, this is really an appropriations bill. What are those conditions?
The conditions are that and again, the word appropriation is attached to this bill, not in its text, but by the Department of Legislative Services by virtue of the fact that it changes a key element of a statutory formula, John A. Cade funding formula for support of community colleges, in a way that requires the governor to include additional amounts in future budget bills. That's
so is that the one, or is it also in addition the fact that it has a funding impact with respect to these young people? Is that a second point? I'm just trying to grasp what it is that if we were looking at this just as a 1, 2, 3, what would be the 1, 2, 3s?
Exactly. The 1, 2, 3s are that it affects an element in a statutory formula, requires the governor to include future amounts, additional amounts rather, for a state program in future budget bills, and third, that it is about conferring a financial benefit. As the Court talked about in Kelly, being a finely tuned scheme, the funding of higher education in Maryland is also, the General Assembly made the connection between the number of in-state students and the amount that community colleges should get. Clearly, presumably, It's because the more in-state students, the more help they need because they're getting, they're getting less tuition money.
Is your point that whenever there's for this fiscal impact of a bill, it's subject to referendum? Is that your argument?
Not that any not that any bill that has a fiscal impact is exempt from referendum. The typical fiscal impact is that there's some new regulation, some new agency that may require funding from the state. That's an incidental effect.
Or it may require the increase in the appropriations that covers that particular category of activity.
That's correct.
That typically would be the case if you passed a law that provided for additional services to be delivered by the state. It's not an appropriations bill, but it invariably will require that there be monies put into the budget to cover that particular service.
But in this, that's true. But that's the kind of incidental effect we think does not exempt a bill from referendum, whereas here, the Department of Legislative Services, this is language that's not used with many bills that's considered by the General Assembly, said it affects a mandated appropriation, meaning that all things being equal, it's not that the governor is required to include a specific amount for a specific purpose in future budget bills.
Are you saying, is that argument advanced by the relationship that I think you're suggesting between this bill and the CADE formula? Is your argument necessarily dependent upon the existence of the CADE formula?
Yes, it is, Your Honor.
Well, then,
absolutely.
would you help me understand exactly how the two interrelate so as to require, which I think is what you said a couple of moments ago, require the governor in future budget bills to include monies that he doesn't currently have to do?
Yes. The reason is that this bill will increase the number of in-state students and the amount of funding under the CADE formula. One of the direct variables or factors in there is the number that they multiply the dollars by is the number of in-state students at the community colleges. That's the relationship. And I can just quote directly from the fiscal note. The general fund expenditures for the CADE funding, page E32 of the joint record extract, general fund expenditures for the CADE funding formula increased by at least $778,000 in fiscal 2014 due to an increase in the enrollments of qualified in-state students at community colleges. This bill affects a mandated appropriation. That's the relationship.
Is this, I suppose, is perhaps re-asking the question that the Chief Judge posed, is this relationship somehow unique? Because I can conceptualize any number of circumstances where legislation would have, as I think the Chief suggested, a fiscal impact down the road.
But a fiscal impact is different. There are not that many statutory funding formulas of this nature to our understanding and knowledge in the law. Another example that does exist, I would offer as an analogy, is the funding formula for for county community health departments. There's a base number in the formula that's multiplied by inflation and by population, and that's the amount that's supposed to go out. It could be reduced by the General Assembly. Of course, the General Assembly can change that law. At one point, recently, they changed the base year from 1997 to 2010, thereby increasing under the formula the amount the governor is required to include in future budget bills. And the question it raises for us is, would that action, direct fiscal decision by the General Assembly, be subject to referendum before the General Assembly could even consider those future budget bills in a way that would suspend, interfere, frustrate the ability of the county health departments to get those funds? The formula is what I think we submit respectfully distinguishes this situation.
So there's nothing about the implementation of the CADE Act that requires the General Assembly to include what the governor is required to include.
That is exactly correct, Your Honor. There is not the General Assembly can reduce virtually anything in the governor's budget bill. And they could also, because the CADE formula is really a statute, it's not a constitutional provision, the CADE formula itself can be amended by the General Assembly before they act on before the governor even puts those amounts in the.
So it's of critical importance to the success of your argument that the DREAM Act must necessarily be considered in conjunction with the CADE Act. It's not you can't make a standalone argument.
Exactly.
The DREAM Act by itself.
Exactly. That is exactly right. Cannot make it's the connection between the two that we believe brings this within the appropriations exception. And again, the connection was drawn not by the supporters of the DREAM Act, but by the Department of Legislative Services, which is responsible for informing members of the General Assembly while they're considering the bill's impact on the state's finances. And as indicated in our brief, the members of the General Assembly were well aware of the relationship with the CADE formula and, of course, had this fiscal note and the connection drawn by the Department of Legislative Services in front of them while they were considering the bill.
Do you have any material disagreement with the way the appellees explain how the CADE Act operates?
No. We don't have with the state. The interveners suggest that the only impact of the formula comes in the distribution of a fixed amount among the various community colleges. That's not really true. Once the governor determines the amount to be spent on the four-year colleges, the formula automatically uses certain variables, and one of the key ones is there are two. There's a percentage, and there's the number of in-state students at all the community colleges for the total amount. So that with that distinction, otherwise we accept their characterization of how the CADE formula operates. And we recognize that the state argues that, and the interveners, that only a bill actually making appropriations or revenue comes within the exception. And it just doesn't seem to be possible, again, given the precedence of this Court, if that were the case on the spending side. Clearly this is not a tax bill. But if only bills actually making the final appropriation were subject to referendum exception, the only ones that would be in it are the budget bill and the supplementary budget bill, or reconciliation bill. And our understanding of the whole...
What's your best case? What's your best case?
For why this is within referendum? Our best case is that, that a law that...
No, I'm talking about what precedent of this Court is your best case?
I'm sorry. Best precedent would be the Kelly case.
Kelly. The
Kelly case, because in that case, and the state, of course, argues, and nothing could be further from Kelly, because these bills were not enacted as a package, not intended to operate together, and it doesn't assign public monies to particular use and so forth. But when the three bills, 1987, that were considered by this Court in Kelly were enacted, there was no public money to assign. The bills created a fund to be funded through future ticket revenue or stadium revenue, which didn't exist, future appropriations that hadn't even been proposed yet, bonding authority which could not be exercised by the stadium authority without case-by-case approval of the General Assembly, contingency after contingency, resulting in no guarantee that a dime would ever be raised or spent for the stadium. But the fact that there was a direction, and again, it's not a perfect analogy, did not involve a statutory formula. Of course, there have been not a lot of precedents of the Court addressing these issues. But it was a direction that the money, if raised, would be spent in a particular way. And we believe that's the situation here. And with respect to the argument that the State makes that the primary object is not to reduce, is not to fund tuition for community colleges, it could have been done more directly. We believe, again, it's not a question of subjective intent, whether this could have been accomplished another way, but whether this is a primary object or incident of it, and based, again, on what the Department of Legislative Services said, that's our, we believe that's the case here. My colleague, Mr. Marson, will address some of the standing issues.
Thank you, sir.
For rebuttal. Thank you, Mr.
Marson.
morning, Your Honors. May it please the Court. With the Court's permission, I'd like to address a few threshold issues addressed by the intervener, MarylandPetitions.com.
You're going to have to keep your voice up, too.
Okay, will do. Precisely because petitions to referendum have constitutional significance in this state, it is critically important for courts to have an opportunity to review the legal sufficiency of those petitions. This is evidently the view of the General Assembly, as the broad and expansive review provisions of Section 6209 of the Election Code show. Section 6209B, under which the registered voter plaintiffs here bring suit, reads in relevant part, pursuant to the Maryland Uniform Declaratory Judgments Act, and upon complaint of any registered voter, the Circuit Court may grant relief as to any petition with respect to the provisions of this title, the Maryland Election Code, or other provisions of law. The Circuit Court found correctly that Section 6209B was a broad grant to registered voters to bring suit, and we think that the text itself shows that the Circuit Court was correct in this regard. Again, any registered voter may bring suit. The Court may grant relief as to any petition, not some subclass of registered voters who are somehow especially affected by the petition, and not some subclass of petitions that somehow have a special connection to the registered voter. It's really a very simple scheme. And in sharp contrast to this simple and broad grant, intervener asked courts in Maryland to size up registered voters and determine whether or not they have a sort of particular enough connection to a petition in order to be heard at all in Maryland courts regarding whether or not the petition conforms to law. We would submit to Your Honors that there is no anchor for this view in the text. And in support of this view, intervener cites a variety of cases under the Maryland Uniform Declaratory Judgments Act, including Hatt v. Anderson. These cases stand generally for the proposition that's uncontroversial, that where a plaintiff sues for declaratory judgment, the plaintiff can't forget that he or she has to have standing, and that there must be a case or controversy, and that courts do not decide abstract questions. We would submit that these principles are satisfied here. The legislature intended to grant registered voters standing. Registered voters here have sued. There is a controversy. Registered voters have come to the court and said the Maryland DREAM Act may not be submitted to petition under law because it is an appropriation under the meaning of Article 16 of the Maryland Constitution. The State Board of Elections says, well, no, in fact, it's going to go to referendum, and in fact, we're going to enlist you upon the request of intervener to become a member of the legislature with respect to this bill. And as the Circuit Court correctly found, your decisions, registered voters, will be outcome determinative with respect to this particular bill, not with respect to bills in general, not with respect to some abstract question, and not with respect to some future election that may or may not take place, but this very election in November that's a few months away. We think that registered voters have a sufficient stake in the outcome of that question to be heard in Maryland courts, and we think that the legislature clearly intended them to do so under Section 6209B. So we would respectfully ask this Court to reject intervener's request to narrow the broad grant of Section 6209B. Now, as to Section 6209A, John Doe is a plaintiff. It's the plaintiff primarily at issue here. He sued under Section 6209A as an aggrieved party. There is one additional fact that we would like to call to the Court's attention that we discovered yesterday that may be relevant for the Court's analysis here, and that is that plaintiff John Doe has in fact been attending a community college part-time, a couple of courses, since the fall of 2011. So he has in fact been taking a few courses since then.
Is that a fact we can consider, given that it was not developed in the record before the Circuit Court?
No, well, whether or not Your Honor can consider it, I'm not exactly sure. I mean, there's an expedited proceeding here. We raise it primarily so the Court's informed, and primarily we also informed the other side of it yesterday so that there would be sort of some transparency there. But if the court can't consider it, it's really of no moment. We think that if the court could consider it, it probably supports the standing argument because intervener raises the concern that John Doe hasn't sufficiently shown that he intends to attend community college. So the standing analysis is probably, if it's affected at all, is affected by in our favor. But in general, the circuit court found below that John Doe had shown enough that to qualify as an aggrieved plaintiff under Section 6209A. He had shown that he intended to attend community college. He had shown that he was the kind of person who was intended to be benefited by the Maryland DREAM Act. And he also had shown that he was not barred from qualifying under the Maryland DREAM Act. So we would submit to Your Honor that given those facts and given the fact that the State Board of Elections made a determination that the petition could go forward and that this petition, in fact, increased his burden for attending community college and made him pay more than he otherwise would, that therefore he qualifies as an aggrieved person under the provisions of Section 6209A. There are specific questions that intervener has raised about John Doe's sufficiency of his pleadings below. We address those all in the briefing. We'd be happy to discuss them here if you're interested. But if there are no further questions, I'll reserve the time for rebuttal.
Thank you, sir.
Thank you.
Bader.
Good morning. May it please the Court. This case is not about the desirability of the DREAM Act or the policy considerations behind it. This case is about the scope of the appropriations exception in defining the types of laws that are subject to the right of referendum reserved to the people of Maryland. In that context, it is a simple and straightforward case. The purpose of the DREAM Act, Chapter 191 of the 2011 Laws of Maryland, is to expand the eligibility for in-state tuition to two categories of students who currently are not eligible for in-state tuition. Changing the eligibility requirements for those two groups of students is not only the primary object of Chapter 191, it is the sole object of that act. I think it was very telling that in response to questions from the Court, Mr. Sandler responded that the appropriation is not actually attached to this bill by its text, but has to come from the Department of Legislative Services fiscal note. The referendum amendment and the appropriations exception in the referendum amendment does not apply to laws that the Department of Legislative Services has determined may have a fiscal impact. It applies to laws making any appropriation for maintaining the state government. The Department of
Mr. Fader, if you could, on that point, Mr. Sandler refers us to the Kelly decision as providing authority for the argument that's being pressed this morning. What's different, if anything, between this scenario and what we considered in Kelly?
They are far more dissimilar than they have any similarities. This Court found in a thorough analysis of Chapter 124 of the bill at issue in Kelly. There were two bills at issue in Kelly. 124 was the one that this Court found to be primarily an appropriation. Looking at all of the aspects of that law, this Court found it to be a very complicated and thorough bill designed to raise revenue in three different ways, all of that revenue being assigned to the specific purpose of constructing two sports stadiums in downtown Baltimore. So the law at issue in Kelly was enacted not only for the purposes of, but the whole design of the statute was to raise revenue for a specific purpose and assign those funds to that purpose. Chapter 191, by contrast, has no provisions that in any way raise revenue, that in any way spend money, that assign money to any particular purpose. It is designed solely to provide eligibility for in-state tuition to two categories of students. The focus of the law is not at all on the state's money, on either raising or spending the money. The focus of the law is on basically creating an equity among two categories of students who are currently not eligible for in-state tuition and those students who are eligible for in-state tuition. The focus is entirely different.
But doesn't that affect the formula of what the state has to contribute? If you lessen the amount of tuition per student for the benefited students, doesn't the state have to make it up, make the difference up through this formula? I mean, isn't there some, whether you call it an appropriations bill or not, isn't there a fiscal impact? I mean, there has to be there's a spending portion of this that comes from, I'm not trying to lead you down a path, I'm just saying that it's like, there has to be some spending aspect of this.
I actually don't think there has to be, Your Honor. This is not this is not a law that requires any spending. It is true that it is possible, if not likely, that in the future, in future budget bills, the General Assembly will decide to appropriate additional funds to community colleges as a result of increased enrollment that may result from this bill. But that is
because there's a recognition, as I understand it, in all of the budgets of the colleges and universities, that there's some that are going to be in-state tuition and some out-of-state tuition. You're saying that it's retrospective in the sense that if they have a formula that provides for so many out-of-state and they don't meet that and they're all in-state, that the General Assembly thereafter can make that up.
The formula actually requires a look back 2 years. The formula says one of the inputs, there are 3 inputs into the formula. The amount of spending on 4-year state public institutions of higher education, a percentage that the General Assembly has in the law that it regularly amends and changes, and then the number of in-state full-time equivalent students. And it's a 2-year look back to determine what that full-time equivalent student number is. But that only goes to the number that the governor is required to put into the budget bill that he submits to the General Assembly. That full-time equivalent number going up does not necessarily mean that any additional appropriation is going to be made for a couple of reasons. One, because the General Assembly can take that number that's put in the budget and reduce it to accommodate whatever its overall budget priorities are. Another is because even before you get to that point, the General Assembly looking forward can and regularly does adjust the percentage, knowing what the full-time equivalent numbers are, in order to come to whatever number it ultimately wants to have in the budget. And we submitted the most recent several years of budget reconciliation and financing acts from the General Assembly that both in the forthcoming fiscal year as well as for about 10 years in the future alter that percentage in order to accommodate the state's long-term fiscal planning. So it's not the case that the enrollment of students going up will necessarily have any impact on the state's contribution. It's very possible that it will. And that's what's contemplated in the Department of Legislative Services fiscal note. But it's not part of the bill. It's not a necessary impact of the bill. And in fact, if there is a marginal increase in costs for community colleges as a result of an increase in enrollment, this bill itself does not suggest whether the community colleges will get any additional funding from any source to make up for that marginal cost. State institutions sometimes have to do more with less, even if they don't get additional funding. And if they are going to get additional funding, this bill does not suggest whether that will come from additional state funding, additional county funding, federal funding, or a decision to raise tuition across the board at the community college in order to make up for those additional costs. That's just not included in this bill at all.
So it's the discretionary nature and the speculative nature of the argument that differentiates this act from an appropriations bill.
That is certainly one aspect.
One aspect.
Yeah, that's one aspect that differentiates it. Another aspect is that those topics are simply not covered in here at all. Unlike the bill at Kelly, which exhaustively covered 3 new revenue sources for the government, several ways in which that could be spent, it didn't actually release the funds because it did require supplemental appropriations through the normal budget process in order to actually release the funds. But it was a complicated mechanism for providing revenue and directing that revenue to the places the General Assembly wanted it to go. This bill is in no way similar to that. It does not raise revenue. It does not direct revenue. It leaves all of those questions, whether there will be additional revenue, if so, from what source, and where it will go, to itself in the future, down the road, in future budget bills. One of the things it will be considering in those future budget bills is whatever number the governor puts into the bill it submits based on the CADE funding formula, but it's not required to follow that number, and the number that the governor puts in is subject to adjustment based on decisions the General Assembly will make in the meantime.
Your position is that a policy, a statute which states a policy,
Yes.
even though it has a financial impact or fiscal impact, whatever that fiscal impact is not covered, and only those bills which have a fiscal impact but which itself states what that fiscal impact is and prescribes how it is to be appropriated are subject to referendum. Is that basically it?
That is, Your Honor. And there are situations where even if a bill states what a fiscal impact would be, that might not be sufficient to bring it within an appropriations exception. But certainly, it must. It must assign, in the words this Court has used before in Kelly and in Dorsey, it must assign public monies for a particular use or purpose. This law does not. This law does not come close to doing that. This law regulates what individuals in two categories are required to pay to attend community college, without saying at all what impact that may have on state funding. The plaintiffs have made much in this case with some language that actually originates in this Court's decision in Weinbrenner about a requirement for the governor to a direction to the governor to include certain money in a budget bill. And I think respectfully that it's taking that quote entirely out of context from Weinbrenner. Weinbrenner involved a case in which the General Assembly had passed a bill that, if not for the timing of its passage relative to that year's budget bill, would have clearly been a supplementary budget bill. It raised taxes. It imposed a 1.5-cent gas tax and directed all of the funds from that gas tax to road construction. And because it was passed before the budget bill, it actually wasn't sufficient in and of itself to be a supplementary appropriations bill just by timing. But the General Assembly, when it passed the budget bill that year, included the expenditure of whatever funds were raised from that tax in the budget bill. So it did release those funds. This Court found that, at a minimum, that law that was challenged constituted a direction to the governor to include those monies in the appropriation in the budget bill, and that the governor did so, and that the bill had to be read as one with the bill that was at issue in Kelly. It wasn't just the fact that that bill directed the governor to do something that made it a law making any appropriation for maintaining the state government. It was the fact that it directed the governor to do it, that he did it, that there was, in fact, an appropriation, and that it had to be considered together as one law with the law that was challenged. And that, of course, is even based on the supposition that this law did direct the governor to do something, to include something in the budget bill. This law, Chapter 191, does not do so. Chapter 191 does not direct the governor to do anything. The referendum opponents are required by the complicated path that they attempt to trace from Chapter 191 of the laws of 2011 through to a future budget bill to make the argument, the untenable argument, that increased funding for community colleges is actually the primary object of Chapter 191. That's an argument that they actually made in their opening brief. In their reply brief, they try to refine that a little bit further by acknowledging that, in fact, the single objective of Chapter 191 is to reduce tuition rates for students, they say, but that financing of that objective is central to achieving the primary object of changing the tuition rates. There are two significant problems with that argument. First of all, financing of that objective, financing is not at all necessary as part of this bill. This bill adjusts tuition that whether these two categories of students need to pay in-state tuition. It does not affect at all how that will impact the state budget, if at all. That is all left to the future. And moreover, financing of that objective, to the extent that there needs to be any financing or that there will be any financing, is simply not covered by Chapter 191 at all. Chapter 191 simply is a bill that changes the policy of the state with respect to who is entitled to in-state tuition at state universities. As such, it is not a law making any appropriation for maintaining the state government, and the decision of the Circuit Court should be affirmed.
Thank you. Mr. Orphanides, I didn't do it right, but you can tell me.
Orphanides, Your Honor.
I'm close.
Very close. Your Honor, intervener agrees with the state's arguments as to why this provision is not subject an appropriation under Article 16. There's a couple other reasons why we believe that the state should affirm the trial court's ruling. Article 16 expressly differentiates between two types of appropriations: appropriations for maintaining state government on the one hand, appropriations for aiding public institutions on the other hand. The exception for aiding public institutions is even narrower than the exception for maintaining state government. We submit that community colleges, universities, and public universities and four-year institutions of the University of Maryland system are public institutions. They're not state government, and that they fall within the even narrower exception to the referability for referendum in Article 16. It's not to say college isn't important, but it is to say that there is an express difference in the law between state government, the various departments and agencies of the state, and public institutions like the University of Maryland, which by law is supposed to be independent, has its own board of trustees, is funded through a variety of means, not only state funding, but also student tuition. Community colleges are even more complex because they're created by the counties. The community colleges' budgets are approved by the counties. Community colleges get substantial funding from the counties. So all of this makes these institutions look more like public institutions, subject to the more narrower exception, than just state government. A couple other points. Continue to be struck by the fact that there is no evidence presented in this case. Plaintiffs haven't presented a single affidavit, a single admission, a single interrogatory answer, a single deposition. All we have as to who the plaintiffs are, how they claim to be injured or impacted by this statute, are pleadings and unsworn statements from counsel. Counsel stood up today to describe or say that there was a new fact, that we now know that John Doe is attending community college, even though in his complaint he said it was very unlikely he ever would be able to go to community college because the referendum puts the Chapter 191 on hold, and even if it's approved by or disapproved by the voters, then he'll never be able to go to community college. There's no facts. We're on summary judgment. The intervener presented an affidavit. There was not so much as a single affidavit describing how John Doe claims to be injured, how he's eligible. There's no evidence showing that he ever graduated from high school. There's no evidence showing that he filed the necessarily Maryland tax returns. There's no evidence showing that he complied with the selective service requirements. Casa de Maryland is another plaintiff. It's claiming that if this bill isn't allowed to go into effect, then its supporters are not going to be able to earn enough money, and that there's going to be more demand for its services. There's no evidence of any of that. It's a very complex, factual recitation of injury that it's laying out, and yet there's no evidence of any of it. The registered voter plaintiffs, we don't know who these people are. We don't know. We don't even know. There's no evidence that they're even registered voters. The plaintiffs didn't present that evidence. Again, not a single affidavit from any of the registered voters saying, I am, a registered voter in the state of Maryland. I am a plaintiff in this action, and this is why this bill is important to me or how it impacts me. So this Court doesn't even need to reach these complex constitutional issues about whether or not this is an appropriation, whether or not it's, an appropriation that mandates an expenditure, what the primary purpose was. None of these issues are even appropriate for the Court to consider under Maryland's longstanding doctrine of constitutional avoidance. There's simply no evidence. With respect to the registered voters, there's an argument, we made an argument that registered voters need to present a justiciable controversy, demonstrate the existence of a justiciable controversy if they're going to bring this lawsuit. That comes straight out of the statute. 6209 says, on a complaint of registered voters pursuant to the Maryland Uniform Declaratory Judgments Act. It's the plain language of the statute. The Maryland Uniform Declaratory Judgment Act is very clear that to bring an action, you have to have more than a disagreement, more than a difference of opinion about a policy matter. You have to have been injured in some way. There has to be some issue, so that a real issue, a real dispute between the parties, such that this Court isn't issuing advisory opinions. There's no showing here. It's not difficult for a registered voter who would enjoy a benefit under this statute to come forward and say, if this goes to referendum, or if this is upheld or defeated at referendum, that I'm going to be affected in some way. That's not a difficult showing to make, and yet these plaintiffs didn't make that allegation, and they didn't present any evidence of it. So what we're doing is we're just looking at the plain language of the statute, and I realize that this Court has not decided a petition case that has answered this question, whether a registered voter needs to show under the Uniform Declaratory Judgment Act that there exists a justiciable controversy. But we suggest the plain language of the statute makes that clear. Yes, they do.
Well, the plain language of the statute just talks about the complaint of any registered voter, right? I mean, that's the plain language of 6209B, pursuant to the Maryland Uniform Declaratory Judgments Act, and upon the complaint of any registered voter. You're importing the language, I gather, when you say plain language, you mean the Maryland Uniform Declaratory Judgments Act?
Yes.
Plain language into that?
Yes.
So it's an incorporation by reference that you're doing?
Yes.
Because the statute itself doesn't say anything other than a complaint of any registered voter.
Well, I think what it says is that the registered voters bring a lawsuit under the Maryland Uniform Declaratory Judgments Act. I mean, that's the plain language of the statute. So what you do then is you look at the requirements of the Maryland Uniform Declaratory Judgments Act. That act clearly says you have to have a justiciable controversy. In fact, the trial court found that. The trial court found that, yes, and I believe even in the lower court the plaintiffs agreed that, yes, you have to show the existence of a justiciable controversy. They just said that the difference of opinion that these alleged registered voters have about the merits of whether or not this statute should go to referendum is sufficient. And we say it's not. That's not a justiciable controversy under the Maryland Uniform Declaratory Judgments Act. So no evidence, not a shred of evidence in the trial court. Registered voters didn't show a justiciable controversy, and this statute's not an appropriation in any event. Unless the Court has any other questions.
Thank you, sir. Go ahead.
Oh, certainly.
What is a justiciable controversy in the context of a referendum litigation?
Well, I could see that if there was someone who was to be a beneficiary under a statute that is going to be subject to a referendum.
Financial or otherwise?
Well, certainly in this case, and this case is unique because the people who are the beneficiaries of the statute, the students, they're unlawfully present. They can never be registered voters. If you take that out of it, that presents a good example of this type of person who might be impacted by a statute going to referendum.
Right, so they cannot challenge it.
They cannot in this circumstance because they can never be registered voters. Casa de Maryland can never be a registered voter.
All right.
The marriage equality bill that just passed, that I don't know if there's going to be litigation over that, but someone claiming a right to marry under that statute and a registered voter could come forward and say, I'm being injured by this statute if it goes to referendum, if it has to go to referendum. So that's what different.
So what does the injury have to consist of?
There just has to be, the law is very clear that there has to be some justiciable controversy. There has to be more than a difference of opinion about a policy matter. So what I'm suggesting is that if the students in this case could be registered voters, they would probably be able to come forward and say, we're being injured because this statute is going to referendum. It's been put on hold. We can't pay that tuition. We can't get that lower rate of tuition now. And if it's not upheld in referendum, we're not going to be able to pay to go to community college. They can't make that argument because they can't be registered voters. They're not registered voters. They don't claim to be registered voters. Any other statute that provides a benefit, and it also constitutes an appropriation, a registered voter in that who's a beneficiary of that statute or who's harmed somehow by that statute, they would arguably have standing. So there's an entire universe of persons who could be registered voters and have the ability to show a justiciable controversy and bring suit under the statute. It's just in this one really unusual circumstance where the people who are claiming the benefit under the statute can't be registered voters where this would really seem to come into play.
Well, the lower court found that the reference to in the statute as to any petition expanded the language of justiciable controversy in the sense that the reference as to any petition really expanded the universe beyond what you're asserting. How do you respond to that?
I make a plain reading of the statute argument.
Well,
and
that's a plain reading of the statute because it says, or will be filed may grant declaratory relief as to any petition with respect to the provisions of this title or other provisions of the law. I mean, the circuit court judge here referred to that language, and that's plain meaning language also. So what do you think in terms of, or is that ambiguous enough to declare an ambiguity in this?
No.
The question, he used this. I'm asking you specifically, what did the language then mean if it doesn't mean any petition?
I think it's just referring to the petition process generally. I don't think it's trying to limit the scope of the Maryland Uniform Declaratory Judgments Act.
No,
I don't think there's any indication.
Expanding the scope, not limiting the scope. I mean expanding the scope as he read it.
I just don't read the statute as loosening the requirements of the Maryland Uniform Declaratory Judgment Act at all. I think if the legislature wanted to do that, it could have done that. It didn't need to include this Maryland Uniform Declaratory Judgments language in there. So if it included that language, it must have intended that have some meaning. And we submit that it has a limiting meaning, that it's a limitation on who can bring an action. You can only bring an action if you can demonstrate a justiciable controversy.
Thank you.
Thank you.
Mr. Sandler.
Thank you, Chief Judge. I just wanted to make three quick points in response to some of the points made by the State. The State contends, and understandably, the focus of the law is not, the DREAM Act is not on the State's finances, but tuition is about money. Tuition is about money. Money is not an incidental dimension of tuition. And just as the regime in Kelly that created by those three bills was characterized by this Court as a finely tuned scheme, the financing of higher education in Maryland is also, under the formula, the amount proposed for four-year colleges relates to the funding for community colleges. Another element is the number of in-state students. These elements are all related, and this is a key element, is directly, not incidentally, but directly impacted by this this bill, by the DREAM Act. Secondly, with respect to the Kelly case, of course it's an imperfect precedent. It was a revenue-raising measure as well. This is not. But the Court did characterize it also as a spending measure, and it was in that context, not in the very peculiar circumstances of Weinbrenner, but in that context that the Court quoted the Weinbrenner language about a spending bill being able to consist of a direction to the governor to include certain amounts in future budget bills. And finally, with respect to the issue that the General Assembly can adjust the amount of what's in the governor's budget bill, that would be true of any law directing spending. If the General Assembly said, we're passing a law, we direct the governor to include in a budget bill $12 million in fiscal year 2013 for purpose X, Y, Z, presumably no one would disagree that's an appropriations bill. The General Assembly is free to say, well, the revenue outlook doesn't look so good. Our deficit's going to go up. We changed our minds. We directed it, but now that the governor put it in there, we're going to cut it. They can always do that. That doesn't differentiate that situation. So
well, it does in the sense that it's in the bill. The appropriation's in the bill.
Right. That's true. In that case, it would be in the bill, but it's not. But just as this, the consequence of this bill is subject to adjustment by the General Assembly in the budget bill and the supplemental, so would that.
Of course. Situation. But the point is, the point I understand him to be making is that you've got to have an appropriation directly in the bill, as opposed to having to look for the appropriation in supplemental statutes or in some other regulations. You have to have it in the bill. Understood.
But the only bills that actually make appropriations, though, are the budget bill and the bill itself, and the Court had suggested that the exception wasn't limited to those. Thank you very much.
Thank you, sir. Mr. Marston? You weren't getting me to leave, were you? Mr. Marston. Judge Radowski, don't feel too bad. He was about to leave.
Well, I will try to make the continued presence worth it with my argument here. Your Honor, intervener has basically revealed in sharp strokes its problem, the problem with its reading of Section 629B, which is that whenever, under their subclass of registered voters theory, that subclass only includes non-registered voters or people who can't be registered voters, then Section 629B is essentially a nullity. And we would submit that, again, given particularly interveners' underlining of the fact that petitions are of constitutional significance. I mean, again, intervener is going to hail registered voters into the voting booth as part of the legislature. It just can't be the case that the General Assembly intended a class of bills not to be reviewable by courts, a class of petitions not to be reviewable by courts under Section 629B, simply because of the fact that the beneficiaries were all couldn't qualify as registered voters under Section 629B. So this hole in the statute, I think, is an effective counter-argument to interveners' reading of Section 629B. And again, as we saw, intervener has no way of really making a good argument for why the any language is in Section 629B, any registered voter, any complaint. We feel that this is particularly compelling. And the Maryland Declaratory Judgment Act does a lot of things. It's a long act. There are a lot of provisions in it, expediting proceedings, parties have to be brought in if there's a constitutional issue brought up. I mean, it's not as if the reference to the Maryland Declaratory Judgment Act was only to the reference to the particular provisions that intervener highlights in this case.
Counsel, what do you say in response to the argument that you didn't present sufficient facts to support your action? No affidavits to support the representations in your complaint?
Your Honor, we have several replies to that. One, when we came to the circuit court, we had set a schedule for the litigation. It did not include discovery. Intervener agreed to that schedule, and we proceeded under that basis. At the hearing, at the motions hearing, we indicated to the circuit court that if the circuit court needed more information, we'd be happy to work with the circuit court, especially in the context of this expedited proceeding. But the circuit court did not ask us for additional information, and we understood that this is the way practice works with respect to these matters in Maryland. In addition, particularly with respect to the registered voter plaintiffs, I mean, interveners said you didn't put an affidavit that these people are registered voters. I mean, their names and addresses are in the complaint. Whether or not someone is a registered voter is a matter of public record. And we, as we indicated at the motions hearing, you know, if this is an issue, we can ask the state to stipulate to it. It's not really an issue. So if there are no further questions, I see my time has expired. Thank you very much.
Don't make that the answer if you haven't finished answering the question.
No, I think that's all I wanted to say. Thank you.
Thank you all.